In 1950, blatant, invidious racial discrimination embedded in law and policy bedeviled African Americans, including those seeking to provide medical assistance and those needing it. Of the 24 or so medical schools in the South, only 5 accepted black students, and 3 of those had accepted only a tiny number grudgingly since 1948. The 2 historically black medical schools, Howard in Washington, D.C., and Meharry in Nashville, Tennessee, educated over 90% of the nation's black physicians. Elsewhere, prospective black medical students were largely unwelcome. Johns Hopkins did not admit its first black medical student until 1963. Duke, not until 1967. Internships and residencies open to blacks were vanishingly rare. And in the South, most professional societies for physicians, dentists, and pharmacists excluded African Americans. For African Americans in need of medical attention, the situation was similarly bleak. If hospital care was required, they could perhaps patronize a black hospital, the downside being that such facilities were often purposefully rendered inferior to white institutions. It was not unusual, for example, for black communities to receive the old hospitals formerly used by whites when whites received new facilities. If blacks patronized white hospitals, they could expect to encounter racial discrimination of all sorts, from being consigned to segregated entryways, elevators, and wards, sometimes in basements, to sleeping on linen marked Negro, to having patient preferences in treatment overlooked by physicians convinced that Negroes did not know what was best for themselves. The most dramatic manifestation of the race line were decisions to refrain from treating blacks altogether, even those in dire need of care. Marjorie Hill was a black woman in Clarksdale, Mississippi, in need of an emergency cesarean section. Though a white hospital was at hand nearby, she was sent to a black hospital in Memphis, nearly 80 miles away, where she and her unborn baby died on the operating table. The Jim Crow era teems with similar episodes, most in the South, but some in the North as well. The Negro woman denied admission to the emergency ward at Sibley Hospital in Washington, D.C., who delivered a child outside on the sidewalk. The wife of W.C. Handy, the father of the Blues, who sat outside the Knickerbocker Hospital in New York City for an hour, suffering from a cerebral hemorrhage, as her physician and hospital authorities squabbled over whether the doctor had engaged in misrepresentation by failing to note that his patient was colored. The 3 victims of an auto accident in Kentucky in August 1950 who were denied admission to the Breckinridge County Hospital because it had no facilities for colored people. The black youngster in Akron, Ohio, who, despite a crisis brought on by diabetes, was excluded from a municipal hospital that declined to mix people of different races in semi-private rooms. The woman who suffered the loss of a child in October 1951 when officials at John Gaston Hospital in Memphis ordered her to return home despite being in labor, pursuant to a policy under which black expectant women could be treated only as outpatients. The most famous hospital exclusion case is apocryphal. On April 1st, 1950, Dr. Charles Drew, the most prominent black physician in America on account of his pioneering research on blood plasma and blood banking, was involved in an automobile accident in a rural county in North Carolina. Although Drew was in fact given medical care by the white physicians who attended him at a private hospital, a persistent rumor in black communities is that he was denied care. Although that rumor has been refuted by careful research, it stemmed from realities that made the rumor all too believable. On December 1st, 1950, 8 months after Dr. Drew's fatal accident, Maltheus Avery, a 24-year-old student at North Carolina A&T College in Greensboro, was driving a car that collided with a truck. The World War II veteran, a husband, and a father of a young daughter, was taken to the Alamance General Hospital, the very place at which Drew had died. At Alamance, doctors determined that, given the severity of his injuries, Avery should be transferred to the Duke University Hospital. He was taken there but stayed only briefly. Although Duke made available a few beds for Negro patients, those were already occupied. So Avery was sent to a nearby black hospital, the Lincoln Hospital. Soon after his arrival, Avery died. It is not at all clear that staying at Duke would have saved Avery. It is clear, however, that consigning him to further travel, given his precarious condition, solely on account of Duke's restrictive racial rules, was a brutal instance of common callousness. Several doctrines legitimated these injustices. One was the idea that formal government-mandated separation of the races, de jure segregation, represented a beneficent or at least innocuous racial distinction, as opposed to a malevolent racial discrimination, and was thus consistent with the 14th Amendment's demand that states accord to all persons the equal protection of the law. Segregation was fatally undermined by the Supreme Court in its landmark ruling in Brown versus Board of Education in 1954, but segregation remained a widespread presence for another decade and a half. Another key doctrine was the state action doctrine, holding that the 14th Amendment protects only against state action, not private action. Misconduct attributable to public authorities, not misconduct attributable to private parties. White supremacists deployed the state action doctrine to insulate schools, associations, and hospitals from a federal constitutional obligation to treat blacks equally, or indeed to interact with blacks at all. A key site of conflict in the struggle over the state action doctrine arose in the context of efforts by black physicians to join professional medical associations. Much was at stake, for example, over membership in the American Medical Association, the AMA. One could become a licensed physician without being a member of the AMA, but absent membership in the AMA, a physician had greatly diminished access to staff privileges at hospitals, to internships and residencies, to fellowships, to grants, and to admittance to specialty boards. Exclusion from the AMA thus imposed a heavy burden on black physicians, impairing dramatically their ability to compete with white peers or to offer high-quality care to their patients. Exclusion from hospital privileges meant that black physicians lost their patients to white physicians when the patients were admitted into hospitals from which African American doctors were barred. This feature of the Jim Crow regime limited the ability of black doctors to capitalize on their medical training. It disrupted the often intimate bounds that surround the doctor-patient relationship. And it further diminished the professional image of black doctors, convincing onlookers, including African Americans, that Negro physicians were inferior to white ones. The exclusion of black doctors from hospital privileges by dint of exclusion from the AMA, affiliation, occurred not only at white institutions directed by whites, it occurred as well at black institutions directed by whites. For a long while, black physicians were excluded even from hospitals at black colleges, such as the Dixie Hospital at Hampton Institute in Virginia, and the McVicar Hospital at Spelman College in Atlanta. Atlanta's Grady Hospital reserved over 300 beds for the use of black patients on its segregated wards, but it did not permit black doctors to practice there until the mid-1950s. The clientele of the New Orleans Charity Hospital was predominantly black, yet the white authorities of that institution denied black doctors staff privileges until the 1960s. The National AMA did not expressly bar black physicians from its membership rules. Rather, it gave local affiliates carte blanche, no pun intended, to determine eligibility for membership. If a local affiliate of the AMA permitted blacks to become members, then they could become members of the national organization. If the local affiliate barred black membership, however, African American doctors in that locale were similarly barred from joining the national AMA. This sometimes created checkerboard results. A black physician from Tennessee traveled to Indiana, where he became a member of the local affiliate, and through that connection, a member of the national AMA. Later, in the 1940s, he returned to Tennessee. He requested that the AMA transfer his membership to his new address. The AMA maintained that he would have to go through the procedures of his new local affiliate, an all-white, racially exclusionary association. When it barred him, the AMA followed suit, since he was no longer a member in good standing of his local AMA affiliate. Efforts to cross race lines erected by local AMA chapters stretch back to at least 1869, when 3 black physicians sought membership in the Medical Society of the District of Columbia. Spurned on racial grounds, the doctors appealed to the AMA, which sided unequivocally with its affiliate, maintaining that the medical society could exclude whomever it wished on whatever grounds it deemed appropriate. For the next 90 years, the AMA repeatedly reaffirmed its policy of permitting local affiliates to impose racial criteria on eligibility for membership. Racial exclusivity in AMA affiliates did slowly recede. They slowly receded for a variety of reasons, including the constant efforts of black physicians banded together in the National Medical Association. The National Medical Association was the association that black doctors created as an analog to the AMA. And the National Medical Association carried on just a relentless campaign, lobbying, cajoling, seeking to persuade in just every sort of way. And this did have some effect. In the early 1950s, local medical societies in the Carolinas, Arkansas, Georgia, and Alabama accepted their first black members. By 1965, however, only one medical association in Louisiana had admitted black doctors fully, while in Mississippi, only 2 had done so. Only 4 of Alabama's 70 local medical associations had black members in 1965, while in Georgia, 68 of 78 county affiliates retained a whites-only policy. In the face of ongoing racial exclusion, some black physicians became more insistent. A few resorted to litigation. The most consequential of their lawsuits, Simpkins versus Moses H. Cone Memorial Hospital, was initiated in 1963 in Greensboro, North Carolina, by 6 black physicians, 3 black dentists, and 2 black patients. They sued 2 hospitals. The Moses H. Cone Memorial Hospital generally excluded black patients, but made an exception for a few whom it admitted on conditions not applicable to whites. When the lawsuit against Cone was filed, it also explicitly barred from staff privileges on a racial basis any and all black physicians and dentists. The Wesley Long Community Hospital completely excluded black patients as well as black physicians and dentists. The plaintiffs asserted that these racial exclusions and discriminations violated their rights under the federal Constitution. The defendants won the first round of litigation when a federal judge dismissed the plaintiff's lawsuit, maintaining that the policies of the hospitals was private and thus beyond the regulatory authority of the 14th Amendment. The plaintiffs, however, prevailed on appeal. The Fourth Circuit Court of Appeals held that the racial policies of the hospitals constituted state action insofar as the hospitals had availed themselves of benefits accorded by a federal law, the Hill-Burton Act. Enacted in 1944, Hill-Burton provided funds for the construction of new or additional facilities for public hospitals or for privately owned nonprofit hospitals. Proponents of Hill-Burton wanted to upgrade and democratize medical services and facilities. They wanted to better the lot of the poor, particularly those in rural areas. But they also insisted upon maintaining the South's traditional way of life, i.e., white privilege and control. In an effort to foreclose legal attack, the architects of Hill-Burton crafted a proviso that purportedly banned discrimination while simultaneously permitting segregation. On one hand, the legislation provided that any plan seeking federal funds shall provide for adequate hospital facilities for the people residing in a state without discrimination on account of race. On the other hand, the legislation provided that an exception shall be made in cases where separate hospital facilities are provided for separate population groups, if the plan makes equitable provision on the basis of need for facilities and services of like quality for each such group. The legislation authorized the United States Surgeon General to promulgate regulations affecting the separate but equal exception to the general non-discrimination regime. The regulations issued required applicants to submit to the Surgeon General a non-discrimination report, enumerating the number of hospital beds that would be available to each racial group in the new facilities. To approve the plans, the Surgeon General had to be satisfied that they offered equitable provision for all population groups. Medical authorities in North Carolina submitted plans indicating that a black hospital, the Z. Richardson Memorial Hospital, would offer 91 beds for non-white patients and none for white patients, while the Long and Cone hospitals would together offer 702 beds for white patients and none for non-white patients. The Surgeon General approved the plan, presumably on the understanding that it fairly allocated hospital resources. Prior to Simpkins, several courts had ruled that private nonprofit hospitals did not become subject to the 14th Amendment by taking Hill-Burton funding and submitting themselves to the state and federal regulations that recipients of that funding were required to accept. In Simpkins itself, the dissenting judges argued that Hill-Burton did not turn the conduct of the defendant hospitals into state action in a constitutional sense. They described their colleagues' conclusion to the contrary as both unprecedented and unwarranted. No court, the dissenters noted, had yet held that the private operation of any endeavor becomes state action merely because its construction or operation has been subsidized by government. But that is all there is in this case. The majority opinion reiterated the sanctity of the state action doctrine, but stressed that in the case at bar, the federal and state governments had become involved in the renovation, expansion, and operation of the hospitals to some significant extent. In play in this controversy, the majority noted, was the appropriation to the defendants of millions of dollars of public money and coordination linking the defendant hospitals with the state and federal governments. Many courts dealing with the state action doctrine proclaim as a matter of principle that they cannot permit their view of the underlying equities of a case to affect the purely legal judgment as to whether the conduct in question is private or public. In Simpkins, by contrast, the Fourth Circuit candidly acknowledged its policy preferences and the pull of those preferences on its legal determination. Not only does the Constitution stand in the way of the defendants' claimed immunity, the court averred, but there are powerful countervailing equities in favor of the plaintiffs. Racial discrimination by hospitals visits severe consequences upon Negro physicians and patients. Punctuating the point, the court described the lawsuit as an effort by a group of citizens to escape the consequences of discrimination in a concern touching health and life itself. Racial discrimination in medical facilities, the court declared, was at least partly responsible for the fact that in North Carolina, the rate of Negro infant mortality was twice the rate for whites, and that maternal deaths were 5 times greater. After finding that the hospital's policies constituted state action, thereby triggering federal constitutional scrutiny, the Court of Appeals granted the plaintiffs all of the relief that they demanded. It ordered the lower court to enjoin the hospitals from continuing to discriminate against black physicians and patients. It also invalidated the separate but equal proviso in Hill-Burton. Important though it was, Simpkins had limited reach. It was governing case law in only one circuit. The Supreme Court of the United States declined to review it. And Simpkins pertained to only a certain sort of private hospital. There were others to which the applicability of Simpkins was quite uncertain. To uproot Jim Crow hospital practices, more tools were needed. 2 that in combination proved immensely useful to racial reformers were Title VI of the Civil Rights Act of 1964 and the Medicare legislation of 1965. Title VI prohibited any organization receiving federal funding from engaging in racial discrimination. To enforce this prohibition, the legislation authorized federal authorities to withhold funds from offending entities. Although this authorization endowed the federal bureaucracy with considerable potential power, it did little initially to alter matters on the ground with respect to hospital care. The task of comprehensive desegregation was so large that the part of the federal bureaucracy mainly responsible for overseeing it, the Department of Health, Education, and Welfare, HEW, was overwhelmed by the challenge. But then, almost inadvertently, HEW received powerful new leverage. The Medicare program, pursuant to which the federal government paid the costs of hospital and other medical care to elderly patients. Now, a government program never implements itself. Administrators implement it and do so in discretionary ways that may vary tremendously depending upon their priorities. In the Johnson administration of the mid-1960s, HEW was staffed by an array of skilled, hardworking bureaucrats committed to eradicating racial discrimination from hospital care. They recognized that Medicare represented a tremendous financial opportunity for hospitals. They then determined that hospitals would be permitted to avail themselves of Medicare funding only upon showing up front that they were in compliance with Title VI, in other words, free of racially discriminatory practices. They made it clear through meetings with local politicians, through press releases, through conferences, through regulations, and through a demonstrated ability and willingness to verify assurances that they were sincerely committed to their stated goal and would, if pushed, withhold funds. They demanded the removal of racial signage in hospitals. They demanded that entrances and exits and waiting rooms be merged. They demanded that black physicians be extended hospital privileges. Exemplifying their determination, administrators held up the funding of scores of hospitals that failed to assure HEW satisfactorily of compliance with Title VI. And administrators abjured altogether certain hospitals that dared to defy Title VI openly. Was HEW wholly unflinching in its encounters with racially discriminatory medical providers? No. It compromised anti-discrimination commitments in circumstances in which denials of care to elderly patients were perceived to be unacceptably burdensome from a medical perspective and or unacceptably costly from a political vantage. It allowed many hospitals to permit patients to escape residing in rooms alongside other patients to whom they had racial objections. It did not demand anti-discrimination certification from nursing homes. It did not seek to regulate at all the racial practices of individual physicians. Still, despite these limitations, deficiencies, and compromises, by 1970, HEW, civil rights attorneys, and activists, doctors, dentists, nurses, and patients had succeeded to a remarkable extent in removing racial discriminations that, 2 decades previously, had seemed unmovable. Desegregation in medical care, though grudging and still incomplete, has proceeded more quickly and comprehensively than desegregation in many other domains. Thank you. So we have plenty of time for questions or comments, or for that matter, objections. So the floor is open.
Oh, I can talk really loud. It's just for the recording, because people are getting credit for this.
We were wondering why the Medicare thing didn't catch nursing homes if Medicare is like for old people.
Yeah. It was largely a political judgment. Also, well, a political judgment and a legal judgment. Nursing homes, especially then, the nursing home industry has really changed. But back then, the nursing homes were often in people's homes. It was a much smaller industry. And so, again, the whole question of what was private and public, it seemed so private. It was in people's homes. And so even, for instance, Lyndon Johnson did not like the idea of nursing homes being put under regulation. It just seemed too private. It seemed like the sort of thing that would really generate a very strong backlash. And so it was partly a doctrinal judgment, but very largely a political judgment that regulation there would be counterproductive.
Can you talk a little bit about the differences across the country in the Medicare implementation? You talked earlier on that obviously the South was more problematic and harsher and their anti-discriminatory policies. But once the Medicare provisions got underway, were they facing resistance from hospitals nationwide, or were the exceptions used sort of equally?
Okay. First of all, it should really be emphasized that with respect to the provision of medical care, this was a nationwide problem. So, for instance, Chicago was notorious in its provision of medical care for racial discrimination. This was a national problem, as was the case with so many of the racial problems that have emerged throughout American history. We tend to sort of focus on the South, but it's a national problem. It was in the South, however, that the race line was probably deepest, most blatant, most stubbornly defended. And in this realm, it was true as well. So, for instance, there were hundreds of small hospitals in the South that, when they were put to the test, either you undergo desegregation or you don't get money. There were hundreds of hospitals in the South that said, "Okay, fine, we won't take the money." So, was the South distinctive? Yeah, the South was distinctive. Were there problems that arose everywhere? Yeah, there were problems that arose everywhere.
I'm curious how your story about opening up medical facilities interacts with the research ethics, the Tuskegee experiment, and the development of regulations there. It's just interesting that you didn't talk about that. I know you had very little time and so on.
Well, I think so. The Tuskegee experiment started I guess it was in the 20s or 30s, there was beginning in the 20s and 30s, there was an experiment in Alabama, in which black men who were infected with syphilis were basically watched to see what would happen. This was a scientific experiment. So, you have some people who are infected with this disease, and then other people are treated with the disease. Let's see what happens. And this goes on for several decades. And it's obviously a wretched, horrifying example of medical experimentation and racist medical experimentation at that. And I suppose some people would, if you were going to just lay out a list of horribles, the Tuskegee experiment would, rank high in that list. So that's right. I mean, the written version of this, the longer version of this, will, of course, talk about Tuskegee. I spent more time on the hospital cases, in a way. Tuskegee, it was terrible. It happened. It was very low visibility. It was sort of semi-secret. And one might say, gosh, it was terrible, but it was unusual. Here, these were very routine, very open. It was a common part of life. People go to emergency rooms, for goodness sakes. So it was the very commonness of this which prompted me to want to focus on this more than Tuskegee. There's one thing that I have found particularly interesting in the subject of the desegregation of medicine is the dilemma that it posed for black physicians. Black physicians there was a wide range of opinion with respect to how black physicians should conduct themselves in light of the happenings that I've elaborated upon. There were many black physicians, by the way, who were thoroughly accommodationist. I mean, if you were a black physician, after all, you were very high up in the in black society. I mean, if you were a black physician, heck, you were an aristocrat in any black community. And in the period after the Second World War, I mean, black physicians, even though they faced what I've outlined, in the decade after the Second World War, the earnings of black physicians went up just dramatically. Again, partly because Burton. I mean, black physicians were doing pretty well. They were, they had a secure and very high position in their communities. There were a lot of black physicians who took the position, I don't like segregation and everything, but I'll take it. I'm not going to rock any boats. I'm doing okay. And in fact, one of the principal campaigns that had to be waged in the attack against segregation was the attack against black physicians who were unwilling to protest. And indeed, there were some black physicians who were not only unwilling to protest, but there were some black physicians who actually saw a benefit to themselves in segregation. After all, with a balkanized medical market, black physicians, in many communities, had captive constituencies. Black people had to go to the black physician, had to go to the black hospital. So they had a captive audience, so to speak. And they were somewhat fearful. You know, if you have one big market, you have more competition. And so there was you had some people who actually, some black physicians who actually, to some degree, embraced the Jim Crow setup. You had some who did not embrace it, but accommodated themselves to it. Then even amongst the people who were activists, there were dilemmas. So for instance, probably the person who actually deserves a strong salute was a longtime member of the faculty of Howard Medical School. His name was Montague Cobb, W. Montague Cobb. He was the editor of the National Medical Association's journal. And he was for the immediate abolition of segregation. I mean, he was an immediatist, a 20th century immediatist when it came to segregation. Out now. And that was his position. Now, he had a fight on his hands, and there were some real dilemmas. So, for instance, what do you do about a situation? I mean, as time went on, as you know, and I only mentioned one lawsuit. There were a whole bunch of lawsuits. As the case law against segregation became larger and larger, as the judiciary started turning more against segregation, as the NAACP Legal Defense Fund started putting more and more pressure on segregation, as things heated up, the white power structure, in an effort to maintain segregation, did in this realm what it did in education and lots of other spheres. It said, the white power structure said, okay, tell you what, we'll buy you off. We'll create new black hospitals, and we'll funnel money to the hospitals. We'll build new black hospitals. Black doctors had to, well, hold it. New hospital, new beds, new places for black physicians, new black heads of hospitals. Do we not accept that? What about the black patients? What about the black patients? We say no to the black hospital, and then we litigate to try to desegregate the white hospital. What happens in the 5 years during which this is in litigation? We tell the black people, wait. There was a big fight about that, and people took different positions. There were some black people who said, listen, we can't be doctrinaire about this. We can't be doctrinaire about this. People got to earn a living. People need medical care. What do we do? And then there were people like Montague Cobb who said, nope, we've got to suck it in. We've got to make our point. Well, here's another dilemma. In the southern states, when the medical associations were beginning to admit black people, a lot of medical associations said this to the black doctors. Tell you what, here's what we'll do. We will make you scientific members of the medical association. What does that mean? That means that you can come to the business meeting. You can come to the business meeting. You can come to the meeting in which we, talk about, the new medical stuff, new drugs, new, theory of this, new theory of that. You can come to that. Now, when it's time to eat, y'all got to leave. Oh, that's true. That's what happened. And that provoked a big, what do you do? In North Carolina, there were black doctors who again, they said, we don't like this. We really don't like this, but we think that it'll be beneficial to go to the meeting. And they did. They were repudiated by the National Medical Association, by the black affiliate of the National Medical Association, who said, we don't like what you're doing. They were censured. And in fact, they were threatened. They were, you're going to have to leave our organization if you accept that Jim Crow inducement. So they didn't. They backed off. Now, there were other black doctors in other places. For instance, I think of two in Mississippi who took the position, listen, we don't like this, but we think it's beneficial. We think anything more we can get. It's not the whole loaf, it's a half loaf, we'll take the half loaf. And they had a dilemma on their hands. And activists, I don't care what the struggle is. That's often going to be the case. Even though you're in a fight against something that's, evil, there's the question of, well, what do you do about it? The question of even whether you file a lawsuit posed a dilemma for black physicians. A lot of physicians, they were big on self-regulation. It was viewed in some quarters among physicians that it was sort of a betrayal of the physician fraternity and sorority, to bring lawyers in. And this was something that played on black physicians as well. So they had they thought, well, what do we do? Do we sue? And even if we win in suing, do we poison the well? Even if we prevail, what happens the day after we prevail with our fellow white doctor colleagues or dentist colleagues? There was do we sue or do we do other things to try to change the situation? For me, I'm finding that to be one of the more interesting subjects behind these developments. Other questions, comments, objections?
I'm wondering about sort of the current situation and if there are ongoing or more recent legal attempts to address the still disparate health outcomes, either from a legislative perspective, from a judicial perspective, or even you mentioned this came sort of from the executive branch and the agencies.
Yeah, well, sure. There are various efforts afoot. For instance, the one problem that has long-standing problem is the problem of information. So, especially over the past decade, there's been a strong efforts to collect more information about the health, differential health consequences of various things. Various attempts to collect information about the way in which different parts of the population respond to different treatments, different therapies. So that's one. The more direct legal attacks have been much more difficult. In the United States, do we still bear the scars of the developments that I talked about? Absolutely. Absolutely. Just think of one. Think of what is in American constitutional law the leading affirmative action case with respect to higher education. What is it? Bakke versus the University of California at Davis Medical School. It was a medical school. And against the backdrop of what I laid out here, against that backdrop, we see a huge fight. What was going on there? What was going on there was an effort to redress the open, not behind the scenes, not subtle, not hiding the ball, the open, explicit, express exclusion of black people who wanted to get a medical education. And by the way, Bakke, in the mid-1970s? Only a decade away from express racial exclusion. And we've seen how hard, and still a fight. Continues to be a fight. So, in terms of education, that's part of it. But does it show up in other areas? Yeah, it shows up in other areas. I mean, the American Medical Association just a few years ago delivered an apology. So finally said, yep. And then they wrote out a report. This is what we did. And we apologize for it. And these are some things we're going to try to do to, make amends. So are there ongoing efforts? Yeah, there are ongoing efforts. But, of course, the layers of this story, they're so deep. I was telling Professor Tushnet, before we all gathered here. For me, this is part of a book I'm writing. This is a subject that I've been deeply interested in for a long period of time, actually. I've taught many, many courses here on American race relations law. I have been, this summer, I spent the summer focusing my attention on the desegregation struggle with respect to medicine. I have relatives. My wife of blessed memory was a surgeon. Her father was a big shot in the National Medical Association. I've known doctors. I had no idea. I had absolutely no idea of the extent to which segregation had an effect on black doctors. I think one thing that happens is we allow things to become far too abstract. We talk about segregation, segregation, government-mandated separation of the races. And we say that, and then we move on. But then, what did segregation actually entail? So racially separated thermometers? Oh, it did. Racially separated ambulance systems? If you think about the day-to-day, just ordinary consequences of segregation, one of the things I'm finding is a need actually to recreate that, because I think it has been lost largely to public memory. Even people who were alive at the time, even their memories dim, and there is a problem of historical amnesia that besets people. And of course, it's even a bigger problem if we're talking about younger people who have no lived experience with any of the history that I sought to outline. Getting the hook? Hook. Thank you very much.